Rise and shine, and we are on day 5, page 5 and 6 of West Michigan Purchase Agreement. We're going to jump right in. So we left off on number 23, where we're talking about possession. Now, to start off page 5, we're still talking about possession. And for purposes of determining possession, the transaction is going to be considered closed once all documents have been signed and received by escrow agent and funds have been received by the escrow agent. So I just want to make a mention here that a lot of people get up in arms about, oh, well, they're not giving us keys at close. Likely, there's many reasons for this, but one of the reasons for this is for this reason right here. Funds have been received, right? So the lender actually has to get the documents, approve the documents, and fund the money. And if that doesn't happen, then it's not considered closed based on our purchase agreement, or it also isn't considered closed because the seller doesn't actually have the money in hand. If the seller fails to deliver possession to the buyer on the agreed upon date, and I would say time, right? Everything's been funded, seller shall become a tenant at sufferance, if you remember that from your real estate class, and shall pay to buyer as liquidated damages blank, right? So this, I usually put $500. People move for $500. If the seller doesn't give possession, or if they give possession and there's stuff everywhere, they left a bunch of objects. This is the number that you'll be able to charge them per day, including any reasonable attorney fees incurred in removing the seller from the property. I put $500. Some people put 100. I've found that people don't move very fast for 100. That's like the cost of a hotel. So if the seller occupies the property after closing, seller will pay all utilities during such occupancy. Seller shall also be responsible for snow removal or landscape maintenance. Buyer will maintain the structure and mechanical systems at the property. However, any repairs or replacements necessitated by seller's misuse, abuse, or neglect of any portion of the property will be seller's responsibility and expense. On the agreed delivery date, seller shall deliver the property free of trash and debris and in room clean condition. Shall remove all personal property unless otherwise stated, and shall make arrangements for final payment on all utilities, and shall deliver all keys to buyer. Now, we just added this, but in the event of possession by seller after close, the buyer and the seller agree to sign a West Michigan temporary occupancy amendment to the purchase agreement. And basically, it's a small tenant agreement. If signed, that amendment shall become an integral part of this agreement. Are there exceptions? Not usually any exceptions. That pretty much covers everything. Now, there could be something along the lines of, if they are allowing them to go past a certain date. Hey, we will not give, you don't need to give us possession 30 days after close. Maybe we'll let you go 90 days after close, which I've absolutely seen. But if you go past 90 days, then this, rent kicks in, or this is the date that you have to be out. Number 24 is earnest money deposit. Now, an earnest money deposit is money that when you get your offer accepted, you put into an escrow account and it holds on to it. So it's usually at least $1,000. Sometimes way more, usually a lot of times way more. But $1,000 is acceptable, and it gets put into an escrow account so that buyer doesn't back out for any reason that's emotional. So buyers can back out due to inspections. They can back out due to appraisal. They cannot back out because their girlfriend left them, and that's why they were buying the house, or whatever the case is. So an earnest money deposit in the amount of $1,000 shall be submitted to, and then your favorite escrow company. This could be the title company if you work with them and are close with them. It could be like ours. We have Amplified Real Estate's holding company. Just whatever your broker decides. So ask your broker. Within 72 hours of the effective date of this agreement, and shall be applied against the purchase price. If the earnest money deposit is not received within 72 hours of the effective date, or is returned for insufficient funds, the seller may terminate this agreement until such time as the earnest money deposit is received. This will also be called the EMD. So if you hear me mention EMD, that is also earnest money deposit. If the sale is not closed due to a failure to satisfy a contingency for a reason other than the fault of buyer, the buyer is entitled to a refund of the earnest money deposit. So if it's not close due to the inspection contingency, or the contingency that they have to sell a house, or the appraisal contingency, then they get their earnest money deposit back. In such event, buyer and seller agree to a written disbursement agreement directing how the EMD shall be dispersed if the sale is not closed as provided in this agreement, and buyer and seller do not agree to the disposition of the earnest money. Then buyer and seller agree that the broker holding the EMD may notify buyer and seller in writing of my intended disposition of the EMD. If buyer and seller do not object to such disposition in writing within 15 days after the broker's notice, they will be deemed to have agreed to broker's proposed disposition. So I would make, as the broker, I would kind of make that decision of what I think it should do, and based on what I know about the situation, and then buyer and seller would have to dispute it. If they object and no mutually agreeable disposition can be negotiated, the broker may deposit the funds by interpleader with a court of proper jurisdiction, or await further actions by buyer. So we can just hold on to it until they decide who has what. In the event of litigation involving the deposit in whole or in part, either buyer and seller that is not the prevailing party as determined by the court will reimburse the other for reasonable fees and expenses incurred in connection with litigation, and will reimburse the broker for any fees and expenses incurred with connection of any interpleader action instituted. So if you are not going to agree on the EMD, you want to be sure that you're going to win it, because you could be on the line for your own fees, seller's attorney fees, the brokerage fees, just because you're causing so much ruckus. If the entity holding the EMD is not the broker, then to the extent that any terms of any escrow agreement conflict with this paragraph, then the terms and conditions of the escrow agreement shall control. Now, professional advice. The broker hereby advises buyer and seller to seek legal, tax, environmental, and other appropriate professional advice relating to this transaction. Broker does not make any representations or warranties with respect to the advisability of or the legal effect of this transaction. Buyer further acknowledges that realtor above named in the agreement hereby recommends to sale of this, hereby recommends to buyer that an attorney be retained by the buyer to pass upon marketability of the title and to ascertain that the required details of the sale are adhered to before the transaction is consummated. I've never seen anybody get an attorney. I know that they have attorneys, but usually they trust me, they trust our title company, to guide them in the right direction. And then the professionals we guide them in the right direction. Now, if you are really unsure or not feeling great about your realtor, or whatever the case is, please get a lawyer. Weird Out Lawyers. Buyer agrees that buyer is not relying on any representation or statement made by seller or any real estate professional, whether intentionally or negligently, regarding any aspect of the property of the sales transaction, except as may be expressly set forth in this agreement. A written amendment to this agreement or disclosure statement separately signed by seller. Buyer and seller acknowledge and agree that the purchase price, terms, and other details in this transaction, when closed, are not confidential. They do get disclosed to realtors who participate in the MLS and may otherwise be used in or published by that MLS service in the ordinary course of its business. So everything is public. Any sale anyway is public, but especially in the MLS, it's going to go to everywhere. That's how we market a lot of things. 27 other provisions. This could be an appraisal gap. This could be where you put your commissions if you're not going to use the commission addendum. This could be where you put your escalation clauses. There's so much in here. And one of the fun things about Dotloop is that you can start writing and it will just bring up concessions, non-refundable EMDs, repairs, short sale. It starts asking you, what you're asking, if there's anything extra. So it's fun to look through all of those. And we can go over on offer enhancements another day. Mergers and integrations. This agreement is the final expression of the complete agreement. There are no other agreements. This agreement may be amended only in writing. So you can't have a word of mouth agreement and say, well, they said. If it's not in here, it doesn't matter. The buyer and seller agree that any signed copy of this agreement and any amendment or addendums related to this transaction, transmitted or other electronic means, shall be competent evidence of its contents to the same effect as our original signed copy. Buyer and seller further agree that an electronic signature is the legal equivalent of a manual or handwritten signature and consent to use of electronic signatures. Buyer and seller agree that any notices required or permitted may also be transmitted. Number 30 is wire fraud. Seller and buyer are advised that wire fraud is an increasingly common problem, and if you receive any electronic communication directing you to transfer funds or provide non-public personal information, such as social security numbers, driver's license numbers, wire instructions, bank account numbers, even if electric communication appears to be coming from me, title company, or lender, do not reply until you have verified the authenticity of the email by direct communication with us, with title, or lender. Do not use telephone numbers provided in the email. Such requests may be a part of a scheme to steal funds or use your identity. That happens a lot. We have never had one with Amplified, thank God. We've never had one with Lighthouse with any of our agents, thank God. But it does happen. Millions of dollars are stolen by wire fraud every year. So it's important that if we say we're going to send you wire instructions, now you get them, receive them, and those are the exact wire instructions. 31, expiration for valuable consideration. Buyer gives seller until, let's just say 10 p.m. on tomorrow to deliver written acceptance of this offer and agrees that this offer, when accepted by seller, will constitute a binding agreement between buyer and seller. And then number 32, buyer is writing this offer and buyer approves the terms of this offer and acknowledges receipt of a copy of this offer. So they're going to initial every single page, then they're going to sign it and put their information. And then it's up to the seller to respond. If they are responding and they accept it as is, then as written, or if they're making a counter offer, as written, accept. And then the counter offers here. Counter offer, if any, expires. Let's just say the seller does counter. They could say, well, it expires at 10 a.m. on the next day, so it's 2 days out. Seller has the right to withdraw his counteroffer and to accept other offers until seller or seller's agent has received notice of buyer's acceptance. So as soon as buyers get this and says, yes, I love it, they can say, yes, we accept it, and then sign it. Seller cannot sell it to anyone else. Until that happens, they absolutely can. Seller certifies to buyer that the property is currently in the same condition as disclosed in the statement dated what? That's where that date comes in. What date is the seller's disclosure dated? Should be the same as at the top. And if it's not, that's why you're putting it, because they might have changed something. Yes or no. Seller agrees to inform buyer in writing of any changes in the content of the disclosure statement prior to closing. Notice to seller. The seller understands that the consummation of the sale or transfer of the property described in this agreement will not relieve seller of any liability that seller may have under the mortgages to which the project is subject, unless otherwise agreed to by the lender or required by law or regulation. Buyer and sellers are advised that a notice to seller and buyer of underlying mortgage form is available from the respective agents via the West Michigan Realtor boards. Put all the listing offices information, seller signature, whether or not they're a U.S. citizen, and then the buyer will accept. And as soon as the buyer accepts a counteroffer, seller has to sign. If there is no counteroffer, then it's just seller signature, buyer signature, nothing. Subject, date, time. All right, everybody, that is the West Michigan Purchase Agreement. That's day 5, page 5 and 6. If you want to check out page 1 through 4, check out the rest of my lives.